The Indian judicial system is the ultimate arbiter of the rule of law for over 1 billion people. Its survival rests entirely on public trust. A lawyer navigating this system occupies a uniquely conflicted position. An advocate operates as an agent tasked with securing a client's victory, while simultaneously serving as an officer of the court. This inherent dual loyalty requires a framework of strict governance. Without rigid ethical boundaries, the power entrusted to legal professionals could easily be abused, eroding the confidence the public places in the legal process. To prevent this, justice relies on a dual statutory shield. First, an internal mechanism, the Advocates Act of 1961, empowering bar counsels to police their own ranks. Second, an external mechanism, the Contempt of Courts Act of 1971, protecting the judiciary's dignity from unwarranted attacks. A common assumption is that these legal liabilities only trigger inside a courtroom during active litigation. The reality is much stricter. The Supreme Court has systematically interpreted these statutes to cast a wide jurisdictional net. The courts consistently punish acts committed entirely in a personal capacity and penalize behaviors even when explicit malicious intent is absent. Grasping these legal boundaries reveals exactly what the law classifies as the administration of justice in India and how aggressively the courts will defend it. Section 35(1) of the Advocates Act establishes the disciplinary power to punish an advocate. The operative phrase is professional or other misconduct. The words or other deliberately expand liability beyond formal duties, pulling acts committed in a personal capacity into the disciplinary matrix. We see this applied in the case of Noratan Mal Chararia v. M.R. Murley. An advocate, acting as a landlord in a personal rent control dispute, physically assaulted and used filthy language against his tenant within the court premises. The Supreme Court ruled that an advocate's conduct must always be measured against the high standards of the profession. Assaulting a litigant demonstrates a lack of moral rectitude that brings disrepute to the entire legal system. The advocate was held guilty of misconduct despite acting in a private capacity. Shifting focus inside the courtroom, the disciplinary net aggressively targets abuses of procedural rules. In N.G. Dastane v. Shrikant S. Shivde, 2 advocates repeatedly sought long adjournments in a criminal trial. On one occasion, they filed a joint application claiming they had a severe throat infection and were completely unable to speak. That same day, they were caught loudly arguing a different case in another courtroom. The Supreme Court held that seeking fake adjournments on false medical pretexts is deliberate deception. It abuses the judicial process, wastes the time of witnesses, and squarely constitutes professional misconduct. The severity of punishment escalates dramatically when the misconduct involves corruption. In Shambhu Ram Yadav v. Hanumandas Khatri, an advocate wrote a letter demanding money from his client, specifically to bribe the presiding judge. The disciplinary committee of the Bar Council of India initially reduced the advocate's punishment to a reprimand out of sympathy. The Supreme Court forcefully overturned this leniency, ruling that facilitating corruption destroys public confidence in the judiciary. They ordered the advocate's permanent disbarment from the profession. The power to punish is balanced by procedural safeguards. In the Monty Goyal case, the Supreme Court struck down a penalty based on bare assertions after the client had sworn an affidavit withdrawing the complaint, establishing that misconduct proceedings cannot bypass natural justice. Section 35 enforces an inescapable ethical envelope. It holds legal professionals to strict standards of citizenship, requiring them to maintain the system's integrity both in and out of their robes. While the Advocates Act polices the profession, the Contempt of Courts Act protects the institution. The statute splits contempt into 2 categories. Section 2B covers civil contempt, dealing with willful disobedience to court orders. The much broader mechanism is Section 2C, criminal contempt. The crucial element in Section 2C is its recurring use of a single verb. It defines criminal contempt as any publication or act that scandalizes or tends to scandalize the court or tends to interfere with the administration of justice. This precise phrasing dictates that explicit criminal intent, or mens rea, is not mandatory. The court evaluates the natural and probable consequence of the act. If an action has the tendency to damage the court's authority, the essential requirement of criminal contempt is met. We see this applied to the first branch of Section 2C, scandalizing the court, in the case of In re Arundhati Roy. During litigation over a dam project, the author filed an affidavit accusing the judiciary of deliberately attempting to silence dissent and stifle freedom of speech. The Supreme Court found her guilty of criminal contempt. Her statements crossed from fair criticism into a scurrilous attack that lowered the dignity of the institution. This principle extends to digital publications, as demonstrated by advocate Prashant Bhushan. He published social media posts criticizing the functioning of recent Chief Justices. The Supreme Court drew a sharp line. Criticizing a judge's personal conduct is private defamation, but public attacks calculated to destabilize public confidence in the efficacy of the entire Supreme Court cross into criminal contempt. The final branch of criminal contempt addresses the physical and structural obstruction of the administration of justice. In the Delhi Judicial Service Association case, police officers in Nadiad, Gujarat, arrested an independent-minded chief judicial magistrate on fabricated charges. They physically assaulted him, tied him with ropes, and paraded the officer through the streets to mock his authority. The Supreme Court ruled that this extreme physical intimidation made it impossible for subordinate judges to discharge their duties without fear. The assault completely obstructed the machinery of justice, resulting in substantive imprisonment for the police officers involved. Obstruction also applies structurally, even when initiated by lawyers themselves. In Bar Council of India v. High Court of Kerala, a regional bar association called for an indefinite strike, locking courtrooms and halting all ongoing trials. The Supreme Court laid down a strict rule. Advocates have absolutely no legal right to strike or call for a boycott of courts. Because an advocate holds a statutory duty to assist the court, forcing institutional paralysis acts as a direct denial of justice to litigants. It fulfills the criteria for criminal contempt. Criminal contempt functions as a strict liability environment. When the institutional authority of the judiciary is threatened, its preservation supersedes both individual freedom of expression and the right to professional protest. To prevent this from becoming an instrument of judicial tyranny, the Act incorporates specific statutory defenses. Foundational protections include Section 3, which protects innocent publication when a person is unaware a case is pending, and Section 4, which shields fair and accurate reporting of judicial proceedings. Section 5 ensures that the public and academics can robustly critique the legal merits of any case that has been heard and finally decided, without fear of reprisal. The Act was modernized by an amendment to Section 13, introducing truth as a valid defense. To invoke truth as a defense, the court must be satisfied of two strict conditions. The statement must be made in good faith, and it must squarely serve the public interest. Furthermore, while issuing an apology is a recognized defense under Section 12, courts have consistently ruled that an apology cannot be used merely as a strategic weapon to escape punishment after launching a calculated attack. Why are the statutory liabilities for misconduct and contempt so severe and uncompromising? These laws are not designed to shield the personal egos of individual judges, nor do they exist to protect an elite status for lawyers. The judicial system possesses no police force or army to enforce its will. Its operational capacity relies entirely on the psychological authority it commands in the public's mind. Striking down ethical breaches, physical intimidation, and institutional vilification ensures the machinery of justice remains unpolluted, trusted, and supreme.